Good afternoon and welcome to this ACT webinar on Know Your Third Party Compliance. I'm Steve Brisby, Deputy Policy and Technical Director here at the ACT. And first I'll explain some technical points about our webinar setup. There is a menu bar across the bottom of your screen that allows you to open various windows, move these around your screen, resize them, or minimize them. The green button with a question mark in it down there is to help if you're having technical difficulties, and another button there opens the Q&A window. You can send in questions by typing in that Q&A window. Please don't wait until the end to send your question. Just send them in as they occur to you, as we will be dealing with them at the end of the presentations. Our practice is that we don't disclose any names. I should add that a recording of this webinar will be available on the ACT website in 2 days' time, along with a separate copy of all the slides. We're delighted to have James Swenson, Head of Operations and Delivery for Thomson Reuters Enhanced Due Diligence Services. Thomson Reuters has sponsored today's webinar, so on behalf of all of us, can I thank them for their support. Thomson Reuters Risk Management Solutions bring together trusted regulatory customer and pricing data, intuitive software, and expert insight and services to empower professionals and enterprises to confidently anticipate and act on risks. Knowledge and understanding of supplier and third-party risk is of utmost importance today for corporates. While there's no one-size-fits-all guidance for supplier and third-party risk management, each organization must know its business well enough to understand where risks may materialize, employee processes to protect them. James is a certified anti-money laundering specialist and has substantial experience designing due diligence programs complying with the Foreign Corrupt Practices Act, UK Bribery Act, Anti-Money Laundering Acts, Supply Chain Risk Management. Today's webinar will hopefully be an interactive discussion on how you can best position yourself and your organization when it comes to knowing your third party. We'll finish with discussion and as many of your questions as we can get to. So James, over to you. Let's get started.
Okay, thank you for that warm introduction, Stephen, and a special thank you to everyone who's taken time out of their busy schedules to join us today. I wanted to start off just by setting the scene and describing a little bit about the specific issues around supply chain and third-party risk management that I want to speak about today. Obviously, this is a very varied topic, and there are a whole bunch of issues, operational and compliance, that play a part as part of a third-party risk management solution system. Companies will often look at things like financial and credit health before onboarding, and also look at ways of monitoring that financial health throughout the engagement of a specific supplier. In addition to that, a lot of companies will look at operational issues, business continuity, issues that may arise, looking at things like political stability, logistical problems around transportation, and also various aspects that might lead them to consider how many suppliers of a certain profile they need, and also looking at specifically which suppliers they want to continue to. The elements that I want to describe today are really around the compliance aspects of selecting new suppliers and also monitoring those relationships throughout the engagement period, and also looking at some of the customer and third-party risk assessment that goes into determining specifically where risks may lie in the onboarding of new suppliers. So for those of you on the call that come from financial services or anybody with some experience in the know your customer due diligence portion of bank client onboarding may start to see that some of these themes are familiar. And what we've done to really develop a KY3P, or Know Your Third Party Risk Management Program, is to borrow some of the best practices that come from the financial services world in terms of how they evaluate risk among their customer population, what levels of due diligence they apply to mitigate those risks, and how they monitor those type of relationships. And really to develop this type of program is a life cycle process that happens from the point of onboarding a supplier to monitoring that relationship and potentially exiting. And part of that really starts with developing a robust program. This involves developing policies and procedures that are documented, that can withstand the scrutiny of a regulator, building and operating controls around that policy. And one of the issues that I really want to focus on today is identifying the risks. So starting to look at how you can establish a risk-based approach, identify certain compliance and regulatory risks, and apply certain levels of due diligence to assess the results of that risk assessment. There's obviously a very important aspect of monitoring and reporting against risks that are identified, and also making sure that the due diligence process and the scrutiny around suppliers is ongoing and not a one-off exercise. There's always the issue around reviewing and aligning those policies. So as regulatory environments change, as new compliance regulations come into play, it's important to make sure that any of these processes and policies reflect any of the changes that may occur in that regulatory environment. And finally, there's a heavy emphasis on training, not only training internal staff that may be involved in the procurement process or may be involved in having relationships with third parties and suppliers, but a lot of organizations are now starting to push training and education onto their third parties, particularly in emerging markets. So they want to make it very what the regulatory environment might be in Western Europe or in North America, and ensure that their third parties understand what those concepts are. Okay, so if we move on to the specific pillars of an anti-bribery and corruption compliance program, this is essentially one of the compliance aspects that a lot of companies have been complying with for many years. So companies that are familiar with the Foreign Corrupt Practices Act in the United States or the UK Bribery Act probably have something very similar like this in place. And these are kind of really the 6 pillars that come out of the guidance notes, both in the UK and from the Department of Justice in the United States, as to how to develop a compliance program that really allows you to identify instances of bribery and corruption in the supply chain. The first one is to really establish proportionate procedures, and a lot of that involves having a risk-based approach as to what your own organization's risks are, and different organizations have different populations of third parties. They're involved in different industries and in different geographies, so it's important to really understand what those risks are to be able to have proportionate procedures in place. Another important component is having a top-level commitment, and if you look at some of the annual reports of a lot of multinational organizations, you'll see a kind of very heavy tone from the top coming from a chairman or a CEO about the company's commitment to having an ethical supply chain, and I think that's a really important component that can trickle down through an organization to ensure that those programs are being held in a variety of different departments within an organization. Again, the risk assessment portion is key. This is really an opportunity for companies to show that they've got processes in place to understand where their risks lie, and that they've taken proportionate levels of due diligence to mitigate against those risks. I mentioned training on the last slide, but this has been identified by a lot of the regulators as an important component, mostly on the internal training, but also on what guidance is given to suppliers and third parties in terms of the regulatory environment. And finally, this concept of making sure that this is an ongoing process. Much like in the banking world, you don't do the due diligence just once at the onboarding stage and then sort of file it in a cabinet. It needs to be an ongoing monitoring and review of these type of relationships. So I just wanted to add the definition of KY3P, if you will. I think the regulatory environment at the moment is very much focused on the supply chain and understanding where the risks are in terms of the procurement of goods and services. But really, the concepts that I'm going to speak about today really apply to a wider third-party population. And depending on what type of organization you're from, that third party may look very different. So if you're involved in manufacturing or heavy industries, you might be looking at a lot of suppliers of goods that are part of a manufacturing process. If you're a software company, your third party might compose more of a distribution channel in terms of who's selling and distributing your software. So it's kind of important to also look at your third party population and understand its composition. Are you dealing with joint venture partners, perhaps in certain jurisdictions that there are local requirements that you partner with a local entity? Are you looking at contractors and suppliers that do business on your behalf? Or are you looking at agents and intermediaries and various consultants? And really, when we talk about a third-party risk management solution, we're talking about this entire population in terms of understanding the risks and having a compliance program to mitigate against those risks. I want to talk a little bit about the concept of a risk assessment. And this is something that, again, is very similar to what a lot of financial institutions do as part of their customer onboarding process. their KY3P. And a lot of the same sort of concepts are being used by multinational organizations in terms of understanding the risks that may lie in their third-party populations. This is a very simplified version. Obviously, a lot of companies that are more complex, that have a variety of different issues that they need to evaluate, may have different variables. But at a very high level, most organizations will really look at these four concepts. If they're looking at particularly issues around anti-bribery and corruption as part of an FCPA or UK Bribery Act compliance program, then there's usually a heavy emphasis on the jurisdictional risk. So companies might determine through a series of sources, either commercially available country risk ranking programs, or they might take information from organizations like Transparency International or the World Bank around the propensity of bribery and corruption in different jurisdictions. They'll generally come up with a country risk rating. And on a simple version, it might say that, suppliers in Scandinavia, for example, are less likely to be involved in bribery and corruption than suppliers in emerging markets, based on these sort of data points that they're taking from various organizations. So they might start to look at applying a greater degree of due diligence and a greater degree of risk mitigation to their suppliers in jurisdictions where there is a greater risk of ethical issues around ethical business practices and bribery and corruption. So using jurisdiction is one of the heavy variables here. The second one is exposure to government officials. And again, this is a concept that is borrowed from financial services in terms of identifying customers that are politically exposed. You may want to look into your third-party population to understand if you're dealing with state-owned enterprises, if you're dealing with organizations that are owned or directed by individuals of government. And again, the idea is that you wouldn't necessarily engage with these type of organizations, but that because of their exposure to government and because of their exposure to the political system in a particular jurisdiction, the probability of bribery and corruption is greater. So it's not to say that you wouldn't engage, but at least that you've identified an additional risk in this particular relationship and may choose to put a greater level of risk mitigation against that particular relationship. I usually like to expand this and not only look at companies and individuals that are politically exposed, but also to start to look at what level of government interaction is that third party going to have on your behalf. So for example, if you're partnering with an organization that needs to get a government license or some sort of permit to do business on your behalf, that should be considered a higher risk situation than a third party that doesn't have that level of requirement. And again, it's not to say that you wouldn't necessarily engage, it's just to understand that there's a greater risk, particularly in terms of bribery and corruption, if there's some sort of interaction with government officials, particularly in jurisdictions that you may have already identified as being higher risk. In addition to that, there's the relationship type, and this is really looking at how strategic or how important is this particular supplier to your process. Are you dealing with one of many companies that supply stationery or office supplies? That might be considered a lower risk situation than perhaps if you think of some of the smartphone manufacturers that have suppliers that are holding a great deal of proprietary and intellectual property. So just the very nature of the relationship that you have with a third party might affect its risk ranking compared to other suppliers that you have in your third party population pool. And finally, I think it's important to also look at the business sector, and that is both an internal and an external exercise. So inherently, some organizations have greater risks for compliance than others. If we look at multinational organizations that are involved in extraction or in the petroleum or defense industries, then inherently there's a greater nature of compliance issues that may arise through their third-party relationships as opposed to organizations that might be involved in retail or other sort of lower risk industry. So it's important to understand not only the industry and the inherent risks that might affect your organization, but also looking at the type of business activities and the type of third parties that you may be looking to engage with. So, what does this kind of look like in a simplified model? So I've kind of taken the various variables here and started to construct an algorithm, if you will, where you're assigning a certain risk category based on the exposure to each of these variables and the intensity of each of these variables to start to bucket the third parties into high, medium, and low risk. So if we have, for example, a manufacturing company, an oil and gas company, for example, that perhaps is looking to do some drilling in a country like Malaysia. Maybe as part of that procedure, the multinational organization has determined that this is a medium risk country in terms of bribery and corruption, again, gathered from data that they've taken from various international organizations. Inherently, the oil and gas and extraction industry might be something that this organization considers to be high risk. In this particular example, you might consider that this Malaysian partner needs to get a government permit and get some government licenses in order to undertake this type of work on your behalf. So therefore, again, that exposure to government officials. And perhaps in this organization's strategy, this particular relationship is very high risk. You know, there's a lot of money dependent on this deal. This deal might have some future implications to the strategy of the organization. So putting a much greater weight on the importance of this relationship with this third party might determine that this is a high-risk situation. And I want to just highlight that just because the determination is that it's high risk doesn't mean that it's not a relationship that you should engage in, or it's not the type of business dealings that an organization would want to take part of, but just this concept that there should be some heightened levels of controls, some heightened levels of due diligence, and some heightened level of scrutiny around the relationship that's being forged with this third party. On the flip side, you might have an example of a North American manufacturing, retail company, that may be interested in placing some products in a location like Canada. Inherently, this might be a low-risk situation given the country, given the type of products that are being sold. This particular transaction doesn't require this exposure to any sort of government licensing or permits. You've done your due diligence around the third party, and there are no political exposed individuals that are behind the company that you're looking at. This might be an interesting project to engage in, but certainly nothing that's mission critical or has a larger impact on the wider company strategy. So in turn, this third party might be deemed as being low risk. So this is the type of exercise that an organization might do on an entire population of third parties, and they might determine that a certain percentage are lower risk, certain percentage are higher risk, and certain percentage are medium risk, and then really what happens there from a screening and onboarding perspective. Again, this is a somewhat simplified model, but I just wanted to highlight it as it's one that many organizations will look at, is applying a certain level of due diligence and screening and monitoring that is proportionate to the risk that has been identified as part of that assessment process. So at a very minimum, organizations should be looking at sanction screening, blacklist and watch lists, and also any prohibited parties lists. And these will depend a little bit on the jurisdiction of where your organization may be registered. So U.S. companies would have to screen against U.S. sanctions, European companies against European sanctions, obviously also taking into account the various jurisdictions where an organization operates to understand your exposure to the various sanctions regimes. And this is something that for many years was perhaps somewhat simple in that the sanction screening you would undertake against specific lists that were prescribed by certain regulators. This has become a little bit more complicated for a lot of organizations over the last couple of years, particularly from the introduction of North American narrative sanctions. So you recall in the last couple of years, particularly OFAC in the United States has introduced the concept of additional sanctions around Russian entities and Russian individuals, and there's now a regulatory requirement that companies not only screen against that specific list, but they also need to understand if any of the companies that they're dealing with have any exposure to those individuals. So no longer just kind of screening against the individual list, but also ensuring that those individuals that are sanctioned don't have any ownership, whether full or partial, in any of the third parties that you're operating with. So this has become a much wider concept that a lot of companies are struggling to screen against. Again, this kind of concept of looking for politically exposed persons or politically exposed entities within that third-party population, and also monitoring any changes to that. So you might be dealing with a third party that doesn't have any exposure to government officials, but all of a sudden one of its owners takes a government position, have an impact on your relationship with that third party. It's important to monitor those relationships as continuously as possible. A lot of organizations have also started to introduce the concept of adverse media, and this is where they're kind of continuously monitoring the press, major business publications to really understand if there are any reputational or compliance type of issues that might arise during the life cycle that they have a relationship with a certain supplier. So at the point of onboarding, a due diligence exercise may be completed, no issues were identified. However, in 6 months' time, that company might be involved in a scandal, or that company might be involved in some sort of ethical business issues that might affect the reputation of the supplier. What processes do you have in place to monitor any of those changes? And then in terms of having due diligence proportionate to the risk, a lot of organizations will then start to add additional components and really move into the concept of enhanced due diligence as they approach the medium and high-risk suppliers. And the idea here is once you've identified a third party that has heightened risk or has additional risk, is to be able to show a regulator that you've taken additional steps to mitigate against that risk. So a lot of companies will start to add things like company status verification searches, and this is really going into a company registry, the equivalent of UK Companies House in whatever jurisdiction you're looking at, to verify that the company is actually registered. Is it in good standing? Are there available documents to allow you to understand who the shareholders and who the directors are? Are there historical documents to allow you to track any changes that have maybe happened in the company's financial health or in the kind of shareholding and management structure? And we've done a little bit of research on this, and in about 80% of the jurisdictions, there's some form of registry search that's available in the public domain, and about 60% where you can get some form of additional documentation around shareholders and directors. So it is important to be aware of what information is available in the public domain, whether or not it can be accessible, and to be able to sort of build a robust program to show a regulator that you're accessing information that is available in order to do the due diligence. There should also be a heavy emphasis on not only treating all third-party corporate entities as solely by concentrating on the legal entity, but also understanding who the directors are, who the shareholders are, who are the decision makers behind that particular entity that you've contracted with, and making sure that the due diligence and risk management procedures extend to the individuals behind the company itself. A lot of companies at this stage also start to look at in-country searches, and this is really monitoring things like adverse media in the local language. So if you've got a third-party population that's heavily concentrated in places like Latin America or China, that you're doing this due diligence in the local language and making sure that you're monitoring the local press and that you're monitoring also local databases that might contain some valuable information around whether or not these companies have been involved in any litigation, whether or not any of these companies are involved in any investigations, and really also checking if there's any issues around financial health through insolvency databases. There is a lot of information that is available in emerging markets. It's just a question of knowing where to find it, and in many cases the information is most likely in a local language and needs to be summarized and translated as part of a centralized due diligence system. In the higher risk scenarios, companies will build on the elements that they've used as part of the lower risk and medium risk due diligence, but may also start to look at some kind of site visits, ensuring that there's a social compliance audit in place, that they've sent somebody to a manufacturing facility to ensure that the stated compliance program that some of these suppliers have are actually in practice. They might do things like reference checks. Really anything that they can gather information that may not be sort of from desktop research, but in terms of references and interviews, to do a more in-depth reputational system, really to be able to show a regulator that they've taken the due diligence as far as they can, given the higher risk, and they've mitigated any initial risks that were identified in that first assessment. So I spoke a little bit before around kind of anti-bribery and corruption, both FCPA in the United States and the UK Bribery Act. These have been the real main drivers for companies instituting this type of enhanced due diligence and risk assessment program. What we've seen over the last couple of years is that there are some emerging regulatory trends in other locations that are really either driving companies to establish these programs if they haven't had them already, or expand the reach so that they're covering a variety of different risk types. I won't go through all of these specifically, but one of the big ones has been the fourth EU money laundering directive and some other regulatory environments. It's really pushing this concept of identifying ultimate beneficial owners, which a lot of companies are struggling to comply with, because there's no single database that really holds this kind of information. And just a kind of a practical example would be you have a contract with company ABC that's registered in France. You want to understand who the owners are. You go to the French company registry, you pull the registry file, and it shows that the company is owned by another corporate entity, perhaps in another jurisdiction. You kind of have to follow the trail to be able to ultimately understand who the individuals are behind that company. And in many cases, due to offshore registry regimes, it's very difficult to come across that information. We're also seeing that a lot of companies might include that as a question on an onboarding questionnaire. So having the company specifically disclose who the owners are, who the directors are, but then really not having the ability to independently verify that information. So, just because a company says it's owned by a certain individual, is there a way in the due diligence process of trying to collaborate that information, which is particularly important in the medium and high risk jurisdictions, and perhaps in some of the jurisdictions where we have this concept of narrative sanctions around companies that are influenced by individuals on the sanctions list, as being able to identify whether that relationship may or may not exist. The other big driver, which I'll focus on a little bit at the end, is the emerging risks around brand integrity and reputational risk. So I'm sure we've all seen that when you go to the supermarket and you buy certain products, things are now certified as being fair trade or ethical business practices behind the sourcing of this material. This has been something that some companies have looked at for several years, but now there's some emerging changes in the regulatory environment, particularly around labor practices, where companies are really starting to extend their due diligence to make sure these issues are covered. And just as part of that due diligence process, the sort of various research elements that I mentioned before in terms of adverse media, in terms of looking at public documents, these are really some of the questions that companies are trying to answer. Basic questions like, are companies duly registered? Are they certified to take part in the type of business activity that they're providing on my behalf? Do they have a complex ownership structure and are registered offshore? Is there a reason for that? Really just trying to understand the kind of track record that the company has and whether or not there's any evidence of any issues that may have occurred in previous business dealings. So one of the things that we see that a lot of organizations struggle with is understanding where to get the type of information that goes into a due diligence process. There's no kind of one-stop single database that you can enter names into that kind of gives you all this type of information. It's really an exercise of having to look in a variety of sources, particularly when you get into emerging markets that may have poorer transparency or a lot of information isn't digitized and made readily available. But generally, we describe information that's used as part of the third-party due diligence as coming from 3 separate sources. There's a heavy emphasis on being able to access public records in official government databases. This would be the type of information that you'd be looking for to confirm that companies are legally registered, trying to get documentation around shareholders and directors from a company registrar, and also looking at things like watch lists and sanctions lists that are published by various official sources, and making sure that that type of information is incorporated into the due diligence process. There's a whole series of commercially available databases as well that really aggregate information from a variety of sources that allow for an easier search. So this is particularly important, I would say, in larger emerging markets like China, Brazil, Mexico, that have often decentralized government reporting systems. So if you wanted to do a kind of comprehensive litigation search in a country like Brazil, you'd have to do a national search, a state search, a city search, and there are certain databases that aggregate a lot of that information to facilitate that type of exercise. And finally, I'd say open sources. A lot of organizations that I work with have started off by simply looking on the internet to see what they can find. Obviously, there are a lot of limitations to that in terms of not being able to access certain sources, but I think certainly it's an important part of the due diligence process because it's the type of information that everybody comes across. So certainly if there's something concerning that comes up in an internet search, whether it be from social media or some sort of alternative type of press, student newspaper, or a pressure group, it is important as part of the compliance process to at least be able to tell a regulator that you came across that information and you risk mitigated against it, particularly if it's going to be readily available and anybody is going to come across the same information that might indicate a risk. So I wanted to just sort of end in talking a little bit about some of the emerging risks that we're seeing in the supply chain. And certainly I think the hot topic for 2015 has been around modern day slavery and what organizations are doing to combat forced and bonded labor in their supply chain. And this is obviously extending also to looking at instances of child labor. There have been several high-profile incidents that have been reported in the press, and I'll talk a little bit about some of the specific examples in the next slide. But I wanted to just highlight that oftentimes the issues that emerge around modern-day slavery in the supply chain are not necessarily always with the direct supplier. They're always within the supplier's web. And this is really kind of influencing the culture around conducting due diligence in that, how far do you follow the trail? If you've done a certain level of due diligence on a main supplier, do you leave it there, or do you try to understand what additional suppliers that first level supplier might be using? And a lot of this has really taken the shape of a lot of organizations making sure that their suppliers are abiding by the same compliance practices that they are, either through education and training or even just sort of making that part of the onboarding process, having suppliers in emerging markets or particularly in jurisdictions where these issues are more prevalent, certifying that they in turn have due diligence and compliance programs in place to be able to mitigate against some of these issues. How significant is the problem? So we've done a little bit of research at this, looking at reports that have come out from the International Labor Organization, different government sites, and also partnering with several that are committed to fighting forced and bonded labor in the supply chain. And it's an estimated $150 million issue in terms of profits that are generated from these type of practices in the private sector. So obviously something very far-reaching and something that is becoming increasingly significant. The conservative estimates are that there are nearly 21 million people in the world that are in conditions of forced and bonded labor. We've also done quite a bit of research to understand what are the more prominent industries where these issues take place so that companies can begin to incorporate that type of information into their risk assessment process. And generally we find that the more labor-intensive industries, the ones that require maybe a high number of migrant workers or seasonal migrant workers, are the ones in emerging markets where these risks are more prevalent. So looking at things like cotton, tobacco, sugarcane, and coffee. There's also been quite a bit of work done, I'd say in the last sort of 2 years or so, at looking at how prevalent these issues are in garment manufacturing, electronics, and also construction. And certainly some of the more high-profile examples that have been reported in the press have been predominantly in these industries. And I think there's been quite a bit of emphasis as well around the issue of migrant laborers in places like Qatar, in the construction industry, particularly around the construction for some high-profile international events. These issues have gotten a much more attention in the press, which has led a lot of companies to making sure that they can beef up their due diligence programs to really start to incorporate risk mitigation against these issues in the supply chain, which has been an emerging trend. So just a couple of examples, and again, if you sort of do a search on this on the internet, there's quite a bit of coverage around it. But in the electronics sector in Malaysia, there's been some issues, again, not directly related to the direct manufacturing supplier that a lot of organizations are using, but more in terms of how those suppliers and those local factories are using a variety of different suppliers, both in Malaysia and outside of Malaysia, to recruit migrant workers into factories. And the main issues there have been around the confiscation of travel documents and also a lot of local labor brokers, particularly in other countries like Nepal, charging recruitment fees that are disproportionate to the salary levels, so that you essentially have individuals that are forced into conditions of indentured servitude. There's also been quite a bit of emphasis on this issue in the seafood industry in Thailand. not necessarily by the direct suppliers, but again within that supplier web of some of the fishing boats that are being used and how they're recruiting workers, and around some of the companies that are actually providing feed for some of the industrial seafood farming, again around the sort of practices that they're using in terms of recruiting individuals to work on some of these fishing farms. And really if you sort of follow these issues in the press, the organizations that get implicated in these are the large supermarket chains, both in North America and in Western Europe. So it really highlights the importance of brand integrity and also how some of these issues might have a reputational backlash for organizations. And some of the drivers for this, I mean, I think this is the interesting aspect of modern-day slavery, is that for many years it was the reputational aspect, the ethical business practices around it. But one of the things that we've seen over the last couple of years is an increase in the regulatory environment. So this really started in California. Companies with revenues over a certain are required by California law to disclose publicly what efforts they've made around eradicating modern-day slavery in their supply chains. Interestingly enough, they don't necessarily need to do much. They just need to disclose their efforts. But what we've seen is that a lot of organizations have really taken that as an opportunity to build out more robust due diligence processes around third parties, and also use that as part of their corporate social responsibility, is to really ensure that there's a level of scrutiny around their suppliers and their third parties around these type of issues. And if you go to any of the major California companies, you can generally see on their websites some published information of how they've tackled this issue. And it's quite interesting how they're working not only in part of their risk mitigation efforts, but also how they're pushing some of these best practices onto their larger suppliers and making sure that there's that kind of domino effect, and that the compliance measures are being pushed down the chain. The second one has been the U.S. federal government, which is the largest purchaser of goods and services in the world. Not only looking at what the U.S. government efforts are, but they've recently started to push a lot of that responsibility onto U.S. federal government contractors, which has really raised the profile of these issues among some of the larger companies in the United States that have U.S. federal government contractors. And there's quite a bit of movement that there may be some additional push within the private sector to adopt some of these measures. And of course, in the UK, we have the Modern Day Slavery Act, which went into effect earlier this year, which is very similar to the California legislation in that its emphasis is on the requirement for disclosure, not necessarily prescriptive in what organizations need to do, but allow that disclosure of this type of information so that consumers can make educated decisions about which products to buy. And we're seeing a whole lot of emphasis from organizations in terms of doing some initial screening within their supply chain as how they can sort of start to look at what suppliers might have heightened risk, and being able to do that sort of risk-based approach, but also pushing a lot of these obligations onto their first-tier suppliers and making sure that the requirements and the compliance regulations are being pushed down the supply chain. And with that, I hope that gave everybody a good overview of just kind of how to handle third-party risk. Happy to take any questions.
Yes, James. We've had a couple of trends in the questions. One is on the slavery and bonded labor. You mentioned there a sort of $150 million profit is probably out there in those kind of markets. Do you have any feel for the scale of the turnover in those businesses? Just how much business is being done, which is catching that kind of labor?
Yeah, I mean, these are high-level estimates from various NGOs, and they vary quite a bit. I think the real issue that a lot of organizations are struggling with is to understand how far-reaching some of these issues go, right? So I think a lot of organizations that we work with on this issue are quite comfortable with the compliance requirements that some of the direct suppliers might have. So understanding from that perspective that the issue might be quite small in comparison. But oftentimes in terms of raw materials and really following the chain is where a lot of the issues lie. So I think it's a little bit difficult to sort of quantify exactly how much revenue is being generated from these type of activities as you follow that chain. But the real concerns have been around, I'd say, the sourcing of raw materials in certain industries, and particularly around the recruitment of migrant workers. So when you put it in kind of dollar terms, you're talking about raw commodities that may not be generating that much profit themselves, or workers that are making very low salaries. But certainly the issue is quite widespread, and one that is really gaining the attention of a lot of organizations.
Okay, and when we're looking at the different national sectors, one of the questions which has come up is in regards to banks which operate in those sectors. Are banks any easier to perform due diligence on? The information any more accessible, or is the same level of care required as, say, for a local manufacturer?
Yeah, that's a good question. It all depends on the jurisdiction, right? So in terms of publicly available information that you can use as part of a risk assessment or as part of a due diligence exercise will vary probably more so on the jurisdiction rather than the industry of a particular third party that you might be looking at. What we see in financial services is generally there's a greater regulatory regime in operation. So sometimes, getting information about banks, getting, financial statements, getting management reports, oftentimes because these are regulated industries, a local regulator might have additional information that you wouldn't be able to access if you were looking at a privately held company, for example, that was a supplier. So it generally is easier to look at financial services companies because they generally operate under a regulatory environment that by nature, again, depending on the jurisdiction, but by its nature might have a greater sense of transparency in terms of providing information. But oftentimes the ownership structure of financial service institutions can also be more complex. So while more information might be available, piecing that information together to really understanding kind of who is behind some of these institutions might present some additional challenges that you wouldn't get from some of the other type of entities.
Okay, time is running short, so I'll do my closing remarks. We have perhaps a couple of other questions out there which we'll try and address separately, particularly entering the realms of cybersecurity and the specifics of money laundering. What I would say is all companies need to keep in mind, of course, there will be sanctions on people who breach other than just reputational risk. But first, my thanks to James and to Thomson Reuters for their sponsorship. This has been a very sponsorship-light presentation by James, which we greatly appreciate, but obviously the Thomson Reuters site will give you access to the services they do provide. Thank you to everybody who joined today's session. I'm sorry if we didn't reach your question within our allotted time. As I said, we'll try and get back on some specifics. As I mentioned at the start, we will be putting up a recording of this webinar on the ACT website, along with presentations in 2 days' time, and we will be sending out a link to that. Looking forward to the rest of the ACT year, we do have some further conferences coming up. The funding conference, the demystifying repos, which is becoming quite popular as people look for yield alternatives, the ACT dinner on the 11th of November, and then we have the Middle East conference and the cash management conference. And we're already looking through and planning for the May ACT annual conference, which this year is in Liverpool. Thank you for listening, and we hope that was informative for you. And I say where we have got unanswered questions, we'll try and come back to you. If you could please take a few minutes to provide your feedback by selecting the icon showing on the screen at the moment, that would be greatly appreciated. Thank you very much.